Hello students, welcome to my channel Learn Law with Professor Rashmi. I am really grateful for your lovely feedbacks that I am receiving. Before moving ahead, I would request you, if you have not subscribed to the channel, to subscribe so that you don't miss the updates and video lectures which are coming on the channel. Moving forward with today's topic, as you know that we have already started with the banking law series and we are discussing banker-customer relationship, different banker obligations and rights. So if you have not seen the earlier video, you can go back to the channel and check that video. I will also post a link of that video in the description box. Coming forward to today's video, it would be a very short video, but this is one of the important topic in view of operational banking. What is the obligation of banker, or what are the banker's obligation to maintain secrecy of customer's account? As you know that account of customer in banker's record has all of his financial dealings, and the customer is depicting the true state of financial position to the bank. These facts are made by the customer, and if these facts or if these records are made public by the banker, it may hamper customer's reputation or customer may incur losses also. So banker is under an obligation to take utmost care and to maintain secrecy about the accounts of the customer. Here banker is under an obligation to take all the necessary precautions to ensure that state of affairs of customer's account are not made public or not known to other by any means. So this is one of the important obligation the banker has. It is not to disclose either deliberately or intentionally any information regarding the customer's account to any third party, and he has to take all the necessary precautions and ensure that no such information leaks from the bank's account. But there would be a certain circumstances where the secrecy can be given away. So bank secrecy rule would be dispensed in the circumstances. Two main circumstances would be when law is requiring such disclosure and when the practices and usages among the bankers permit such a disclosure. So disclosure of information which is required by law. Coming to disclosure required by law, you will see that banker is under a statutory obligation to disclose the information. So customer cannot say why this information was disclosed, because by law here banker is required to disclose the information and there is no other way out that banker can run away from disclosing the information. First is Income Tax Act. As you know that under Income Tax Act of 1961, the two sections, section 131 and section 133, in both as per both the section, in first case the income tax authorities possess the same powers as they are vested in code under Civil Procedure Code, that is CPC. So it can enforce the attendance of any person, which also include any officer from banking company, examine him on oath, compel the production of books of accounts and other documents. So in such case, if banking company or any officer of banking company is called upon to divulge any information, then there is no option but bank has to divulge with such information of customer's account. Section 133 empowers income tax authorities that it can require any person, which also includes of course a banking company or any officer thereof, to furnish information in relation to such points or as required any furnishing of statements of accounts or any other information in relation to that, and income tax authorities are authorized to call for such necessary information from banker. So you will understand that as per the Income Tax Act of 1961, if there is any information called by the income tax office or any officer thereof, bank has to disclose such information of the customer's account. Under Companies Act of 1956, where central government is appointing an inspector to investigate the affairs of any joint stock company under section 235 or 237 of the Act, then it is duty of officer or other agents to produce all books, papers relating to that company. So here bank accounts will also come in the purview. So banker would be under an obligation to disclose all the information regarding the company, but not of any other customer beyond the purpose of this investigation. This is important. Then Bankers Book Evidence Act, you are all aware that as per the court order, when court is ordering banker to disclose any information relating to customer's account, banker is bound to do so. And as per the Bankers Book Evidence Act, the certified copies of the entries in the Bankers Book would be treated as sufficient evidence, and production of books in courts cannot be forced upon bankers. Under Reserve Bank of India Act. So Reserve Bank of India always keeps on collecting the credit information from banking companies, furnishes the consolidated credit information from banking company. Every banking company is under statutory obligation under section 45B of RBI Act that any credit information which is required by RBI has to be furnished. Of course, this information, this credit information which is supplied by RBI or supplied to RBI would be kept confidential. Next, under Banking Regulation Act, so under section 26, every banking company is required to file a return of all such accounts which are not operated for a period of 10 years. So here the dormant accounts basically. So here banking company is under obligation to divulge this information. Disclosure to police. When we talk about disclosure to police, CRPC under section 94(3), police officer who are conducting investigation may also inspect the bankers' books for the purpose of such investigations. Then under FEMA Act, Foreign Exchange Management Act, banking companies dealing with foreign exchange business are designated as authorized dealer, and when RBI is empowered or is asking for such any information from an authorized dealer who is a bank, then this information has to be given. So all the information has to be produced, may it be books, accounts or other documents which are in the custody of the bank, and it would include, so this is the information which can be divulged as per the FEMA Act. Under Credit Information Companies Regulation Act of 2005, every credit institution who is member of Credit Information Company has to provide credit information, which is so all banking companies are included under this, and here this requirement becomes mandatory by bank. Now, whether Right to Information Act is applicable to bank. So we know that main objective of this Right to Information Act is basically enabling the citizens of India to have access to the information of public authorities, so that there would be transparency and accountability in these organizations. Then, is a bank public authority? So banks are commercial organization and do not fall under the category of public authority. They function on the basis of confidence which is reposed by public in them. So here they are not bound to disclose any information about customers' accounts. So RTI won't be applicable to any commercial bank, but Reserve Bank of India, being a public authority, it is under obligation to provide information to public. So this was all the disclosures which were required by law, where bank is not under an obligation to maintain the secrecy of customers' account. Now, what is disclosure by practices and usages? Apart from law, there are different practices and usages. Those are prevalent in banking industry, where such disclosure is said to be valid or justified. So with the express or implied consent of the customer, so banker is justified in disclosing any information relating to his customer account which is by his consent. Such consent can either be expressed or it can be implied. Also, banker can disclose any information to legally protect his own interest. For example, suppose this banker is required to recover the dues from the guarantor. Here it becomes necessary that the person who principal debtor's information has to be revealed to the guarantor or to the solicitor, as the case may be. So it is quite justified that bank is going to reveal such information. Then banker's reference. Here now I'll tell you that in banking there is a practice where bankers amongst themselves follow such practice, that they make necessary inquiries about the customers, their sureties maybe. So this is an established practice amongst the bankers, and it is justified on this ground that it is considered to be an implied consent of the customer which is presumed to be existing, and that is the reason by custom and practice necessary information or opinion about the customer is furnished by the banker confidentially. But it is very important to note here that whatever opinion which is given by the banker should be without any bias or prejudice. It should be an honest opinion. No fact should be misrepresented deliberately. So as per banker's reference, banks can divulge the information confidentially. but or opinion about the customer. So if I am going for a credit facility in a particular bank and I am having an account in another bank, so it is practice between the two banks that one bank can approach the other bank and ask whether this person has the credibility that such credit facility can be granted. So other bank is supposed to give the opinion as per the established practices or usages, you can say. Here, if bank is giving this information in a biased way, then bank would be at the fault. So it is to be taken care that bank is disclosing the information on the basis of honest and clear facts. There should be no bias, no prejudice, and no misrepresentation of any fact should be done. Duty to the public to disclose. So banker may justifiably disclose any information relating to his customer's account when it is his duty to the public to disclose such information. So for example, a government official is asking for information for commission of any particular crime, and bank has reasonable cause to believe that crime has been committed, then such information can be divulged. If bank is considering that customer is involved in any activities which are prejudicial to the interest of the country, where the bank's book reveal that customer is contravening the provisions of any law, when sizable funds are received from foreign countries. So suppose in any account, if there are a huge amount of funds which are received from any foreign countries, here bank can disclose such information to necessary authorities so as it is not against the interest or benefit of our own country. So they are not prejudicial. So in such cases, the information can be divulged. What would happen if there is an unwarranted or unjustifiable disclosure by bank? So you know that bank is under an obligation to keep secrecy of his customer's account except in the circumstances which we have just discussed. So even after closure of the account also the secrecy has to be maintained. And if there is an unjustifiable or unwarranted disclosure happening by the bank, then customer may sue the banker for the damages suffered by him as a result of such disclosure. Substantial amount may also be claimed if the customer has suffered material damages. So this was all about the banker's obligation to maintain secrecy of customer's account. In upcoming lecture, we are also going to discuss about banker's obligation to honor checks, what happens when garnishee order is coming, what are the banker's right of general lien, what are the banker's right of set off, and all those things. These are the important topics with respect to operational banking. So we are going to discuss this in upcoming lectures. Stay tuned to the channel. Till then, keep studying. Bye. Thank you.